Mr. Chairman, we are live.
Thank you very much. My name is Richard Riley, Litchfield Zoning Board of Adjustments. This is a special meeting of the Zoning Board. I'd like to call the special meeting to order at 7:02 p.m. on August 20th, 2020. We can just do a quick roll call, announce who you are. Again, I'm Richard Riley. We have Mark Collado with us. We have John Devereaux with us. We have Laura Gandia with us. So we do have a quorum of 4 persons present. So we're able to move forward with the meeting. What I want to do, though, I know both yourself, Laura, and John, we were involved in this case back in June of 2020 this year. So we are familiar with all the documentation, testimony that's already been given. Mark, have you had the opportunity to read through all the documentation that was provided on this case?
I have.
Very good. All right, so we do have a quorum. We have 4 members present. We're here at this special meeting to hear a motion for rehearing. The motion was filed by Tammy Law, and this is a motion to rehear case number 2020-04, which was a variance from Litchfield zoning ordinance section 310.00, where the board granted a variance of 39 feet into the 50-foot right-of-way setback, essentially allowing the placement of the shed to be 11 foot from the property line. So that's what we're here to discuss. That's all we will be discussing based on the rules governing the motion for rehearings. There will be no public input. There will be no additional testimony given. I am going to ask Laura Gandia, ZBA Vice Chairperson, to assist with this review process of the motion. Essentially, Laura, if you could help us, maybe by starting to help us understand what is the level necessary to grant a motion for rehearing, and then step us through the motion that was filed so that we can kind of apply that, what you're telling us to the motion that's before us.
Absolutely. The motion for rehearing is, and I know Richard sent out some really good reading material to the board, is governed by statute, which is RSA 677:2 and RSA 677:3. And the person who's filing the motion for rehearing has the burden of proving that the board made a mistake by basically misapplying the facts or misinterpreting the law. So the burden or onus is on the applicant, in this case, the person who's filing the motion for rehearing, to basically set forth everything that they feel that the board did was unlawful or unreasonable. So again, it's really important to understand that the burden is on that person who's filing for the rehearing. And it's also important for the board to know that if there's evidence that could have been presented at the hearing and was not presented, then that's not a basis for a rehearing. And for example, in any case, if somebody came, whether in favor of an application or in opposition to it, and they weren't properly prepared, and then the decision was made and not in their favor, they can't come back and say, oh, well, I wanted to show you this at the hearing, but I didn't because of whatever reason. So it's not a chance. They don't get a second bite at the apple. So it's not that type of process. It's we did something wrong, or there was evidence that wasn't available to them at the time of the original hearing that has now become available. So for example, and I'm going to be a little bit extreme, there was, a new scientific breakthrough since June 10th that had to do with, a fact concerning, this case that nobody had at that time. So now just came forward, and that could potentially be a basis for a rehearing. Does that make sense to folks?
I believe it does.
All right.
Yeah, I understand.
So
And
now,
I believe some of the requirements also, the person filing the motion needs to be a party, an affected party. I'm not sure of the exact language.
they need to have standing.
They have to have standing. That's what it is. Okay. And I think in this case, being the abutter, they certainly do have the standing to file the motion, so that, they get right past that first hurdle.
Right. And, the state, they, have also said, we should not grant rehearings lightly because that would, basically lose all importance and no decision of the board would be final until 2 hearings have been held. So this is, under very certain guidelines should, and standards should a motion for rehearing be granted. And those are basically new evidence that wasn't available at the time of the original hearing, or that we made a mistake by misinterpreting facts or misapplying the law. That's really kind of it. It's very narrow, and that's really so. With that, we need to take a look at the motion that was filed by Tammy Law, and there was a motion filed by Tammy that was timely, and she basically put forward 3 points that she wanted us to consider, and Rich, you have it up on the board. And the first one is that out of the 5 points, contrary to the public interest and safety. So she states, first and foremost, the shed is illegal. It was built in defiance of an order per town administrator and building code inspector. The footprint is a permanent negative fixture. And she goes on and basically talks about how Talent Road is heavily traveled. And she said, Jim and I strongly fear with the amount of changes made next door to a half-acre or more, terrain alterations, shoulder, part-time driveway, that this should have gone through the planning board. It is comparable to a new build. Perhaps with the shed, we have reasonable recourse to the town. We are currently doing what we can to preserve the neighborhood. So if you look at that, I don't believe, and this is where we need to have the discussion, that she's saying that we did anything wrong or that we misapply the facts. She's basically reiterating what she said at the first hearing. And we heard those facts and we heard her opinion. So the board needs to decide, did we do anything wrong as far as the public interest in safety? Or did she allege that we did anything wrong? And she's not alleging that we did anything wrong. She's basically just putting forth her opinion again. If she was alleging that we did something wrong, the motion should contain language such as the board failed to do such and such, and she did not do that in this motion. She's just, in my opinion, basically reiterating her dissatisfaction with the board's decision and things that she thought that she previously expressed as to why she did not want the variance to be granted. And the second one is the spirit. The rural neighborhood is zoned residential for a reason. The roadside shed, fence, and black gate look like commercial or city property. The character has changed. Many people have stopped to ask me what is going on. They do not like the appearance. Again, she's just putting forward her appearance. She's not saying that we did something wrong, that we misapplied the facts. She's not offering any evidence that wasn't available to her at the time of the hearing. Furthermore, the fence, the black gate, that's not in our purview at all. It was the shed, and we did have in-depth discussions with her and the board during our deliberations about the shed and the character of the neighborhood. And the third thing she has is negative financial impact. We have a letter from Josh Jordan, our realtor, that explains why this affects our property value. Attorney Greg Palkin has advised us that this shed should be placed outside our immediate view, and should we agree to a compromised location so as not to diminish our value. And she kind of in her beginning talks about compromising. The purpose of a motion rehearing is not, we can't give a compromise. Only thing we can do is do a yes or no vote, whether or not to rehear it based on the standards that we previously talked about. So the negative financial impact she mentioned during the original hearing, and we consider that. She's now coming to us with a letter from a realtor. We can't consider that letter for a realtor because that is evidence that was available to her. If she wanted to have a realtor testify at the original hearing, she should have done so. And it goes to the point of being prepared for the initial hearing. And we can't give a second bite at the apple to say, oh, well, now you want to have us look at a letter from a realtor. That should have been presented at the original hearing. And regardless of that fact, we still did consider, and she did put forth her opinion that it would affect her property values. And that was her 3 points for her motion for a rehearing. And based on that, it's up to the board to decide, did she present any evidence that wasn't available to her at the time of the hearing? I did not see any. Did she say that we made a mistake in misapplying the facts and misinterpreting the law? And she did not do any of those. But if the board wants to discuss that further, we should do that.
All right. So Thank you very much for that explanation. It was helpful. Just for clarification, a rehearing, in the event of a rehearing, if it were granted, that brings you back to square one. Is that correct?
Yes.
Essentially, we re-notify the public, we rehear everything right back
Yep.
from the beginning again.
Right.
So what I would like to do with the group here is, I want to make sure we have that discussion as Laura referenced, on these 3 points. I think Laura has certainly framed the 3 points for us. So let's just kind of go through these things one at a time. I'm going to start with the easiest one. I'm going to go backwards, starting with the 3rd point, which I think Laura's explanation that, this is evidence that was available or could have been presented at the time of the original hearing. I think that's clear here. I also think the language in the RSA is very clear about that. So I would have to agree that number 3 in particular, at least from my perspective, that we could not grant a motion for a rehearing based on the 3rd point. And I'm going to lump in the photos as well, because from what I can see, many of these photos are either the same photos we've seen or would have been available, could have been presented, pretty much tell the same story or paint the same picture as the photos that we saw at the original hearing as well. So I know, Laura, you didn't touch upon all the attachments, but I'm kind of lumping that all into number 3, where, it's evidence that, we've either already reviewed or, they could have presented it at the time of the hearing. I don't know. Go ahead.
I was just saying, which I would agree with the pictures, lumping those in as well.
All right, so I'm going to ask, Mark and John, and I'll start with Mark, if you would mind. Just go ahead and tell us how you feel about number 3 in the pictures.
Yeah, well, I originally read through all the original documents, and I don't feel that there's any evidence that we missed or was skipped in that. So I don't see that point as being a valued point.
Thank you. How about John?
I see no new evidence, so I don't think they really have a grounds for a rehearing according to the law.
I think maybe there is new evidence in that letter itself from a realtor is new evidence, but I think the point that we need to emphasize here is we're not really allowed to look at that new evidence here. It's evidence that would have been available to this person at the time of the hearing, and it's really incumbent upon them to come prepared. Otherwise, you put us and, more importantly, the owner in a situation where they never know when they're going to get a decision, because somebody could just keep bringing back something new, some new angle. You know what I mean? So I think the law is very clear for that reason.
Yeah, it clarified. New evidence that wasn't available the previous time. Yes,
Okay.
that would be better said, right?
Just wanted to make sure. All right, so
We got Kyle.
We have Kyle on the line.
Sorry about that. I had trouble with the link here.
Before we get going, let me ask Laura. Laura, can we add Kyle to the discussion, or should we just move on to just the 4 of us?
No, I would add him.
All right. So we're going to add Kyle Durso to the zoning board. Actually, I believe, Mark, I have to assign you to Kyle, I have to assign. Kyle, I'm going to assign you to the board tonight as well, because you're an alternate, so I'm assigning you on the board. And the reason why it's I think, advantageous to have Kyle here is Kyle was the 4th member in June when we heard this case originally. So, Kyle, just to bring you up to speed, Laura has walked us through essentially the definition of a motion for rehearing. She kind of covered a lot of the important points in the RSA relative to this motion for rehearing.
Excellent. And I was able to listen in online while I was trying to get the link going, so I heard where we got to date.
Oh, that's good.
That's
That's really-
fantastic. So why don't you weigh in? Right now, we're looking at the point in her motion, in the motion that was filed, I should say, from Mrs. Law. We're kind of weighing in on point number 3, which
Yep.
essentially references the realtor letter, and then we're lumping in the photos that were attached to the motion as well with this.
Right. Yeah. No, I agree that the letter should have been provided at the time of the hearing as initial evidence.
Okay. All right, so I'm going to move up from there to number 2. The rural neighborhood is zoned residential for a reason. The roadside shed, fence, and blockade look like commercial city property, etc. I think, Laura, I think you summarized this by saying there really is no direct claim here as to a technical error or an improper decision.
Correct.
It really does seem to be reemphasizing what was stated in the June hearing.
Right.
I think it's plain for me, so I would have to agree with that assessment. So, in my opinion, number 2 doesn't rise to the level of granting a motion for rehearing for me either. So let me go to you, Mark, again.
No, I believe it's opinion and hearsay and doesn't really, I agree with you, Rich.
Okay, and John,
Excuse me?
I just wanted your opinion on number 2.
Oh, I agree. I agree that there's no new material that would be adequate for a rehearing.
Okay, and then Kyle.
Yep. I agree.
All right, so number 1, I left one for last. So I think it's a little trickier. So first of all, the shed is illegal. It was built on an old farm, et cetera, et cetera. Do not find any changes. Okay, so Laura, can you explain the reasoning of your position on this one?
Yeah, I mean, it's very similar to 2. I mean, we can go through it. First and foremost, the shed is illegal. That was talked about at the hearing, so she's not arguing anything. Everybody knew that fact was correct, and there was, communications between the original applicant and the town regarding that. Again, in defiance of an order per the town administrator and building code inspector, that was all discussed previously. The footprint is a permanent negative fixture that is temporarily and partially screened out of view. We talked about the shed in great detail. Talent Road is heavily traveled by high school traffic and others. And we talked about that, the visibility. I remember Mr. Law talking about cutting back trees and working with the town to cut back trees. And then that's her facts. And then she says, Jim and I strongly feel with the amount of changes made next door. And we did talk about the changes. We talked about the grading and the drainage and the puddles. And we went through an extensive discussion about that. There's a part-time driveway, fence, propane tank location, that much should have gone through the planning board. That's not the process. This would never go through the planning board. It's a residential development for a house. So it wouldn't even see the planning board to do this. So I think she's just looking for another avenue to be heard. And it wouldn't be the planning board. It would be basically the zoning board, because he was seeking relief from one of the zoning criteria for the town. Perhaps with the shed, we have reasonable recourse. That's just a question. So everything here is again, it's the same thing. She's just reiterating stuff that she put forward at the original hearing. She's not saying that we did anything wrong. So she's not complaining that we committed a technical error. Those are facts that were put forward during the original hearing, were discussed and flushed out during there. So it goes back to the same type of analysis for 2. Again, there's no technical error. She's not complaining that we did something unlawful or unreasonable, and that's right in the statute 677:3, that, it shall set forth every ground upon which it is claimed that the decision and order complained of is unlawful or unreasonable. She never once said that what we did was unlawful or unreasonable. She just doesn't like the decision.
Yeah, all right, I understand. One of the reasons, I guess I should say, the only reason why I struggle with this one in particular is because I personally feel I think I was the lone dissenter in the vote. And I just feel I didn't do a good enough job explaining why I was, not in favor of it. And I think my biggest concern was the contrary to public interest, in that, to me, the public interest is having these rules in place. And my sticking point was a shed being completed after a cease and desist order was issued, and then the applicant using, the cost of moving a completed shed as a major part of the reasoning why why they wanted or needed the variance. But my reading of the RSA, this isn't a motion for a hearing, isn't an opportunity for a board member that lost in the decision to reiterate their stance. Is that correct? Is that fair for me to say?
No, I don't think it's an opportunity. If you had an issue with your decision, you technically could have filed your own motion for a rehearing and stated that. And I have seen zoning boards file their own motion for a rehearing to correct a mistake. I think what you're saying, you didn't make a mistake.
Right.
You put forward your position, and your position, I think, was heard. Whether or not you think you should have been more forceful or not wouldn't rise to a level of a rehearing. And if it did, it would have to come from you.
That's what I thought as well. And frankly, I'm not sure. I don't really think it would have made a difference in the decision that was made. So I just wanted to kind of get that out there. I also want to cover one more point on the technical errors. I had received an email from Mrs. Law, and I believe this was dated June 4th, 2020. I just want to get this in the record to make sure, because as I was going through my notes, I came across this. What she was pointing out to me, and I'm not going to read everything verbatim, but basically what she was pointing out was that in the registered letter that we sent out notifying the abutters of the case that was to be heard back in June, she had noted that my wording on the case number 2020-04, variance for LZO section 310 to allow a shed, which has, and I'm quoting here, to allow a shed which has been constructed within the minimum setback requirement, period. The shed encroaches 39 foot into the ROA setback requirement of 50 foot. Her point was that she felt that my first sentence was misworded. It should have stated that the shed was not constructed within the minimum setback requirement. I'm not sure about whether that word makes a difference or not, but I'm comfortable with my second sentence, which clearly states that the shed encroaches 39 foot into the right-of-way setback requirement of 50 foot. That clearly states what was being sought. So I think in that case, the public notice was accurate, and I don't think that's a technical error that would rise to the level of a motion for rehearing. I know she didn't bring that in her motion, but I just wanted to get that out there to make sure that I got that covered. So
Yeah,
go ahead.
Oh, Rich, I just said I would agree. I think one is not part of the rehearing, so it can't be considered. And two, I don't think that's a technical error that would, if it was included, would rise to the level of granting a rehearing.
Okay. So I think we've covered the 3 points in the motion for the rehearing. And what I'm going to do is ask if anybody has any further comment. And before I go ahead and ask for a motion on this motion for rehearing. Having no further comment, I'll ask for a motion on the motion.
Mr. Chair, I'd like to make a motion in case number 2020-4 to deny the request for a rehearing based on the fact that there was no new evidence presented that wasn't available and there was no mistake or error based on part of the board.
All right, so we have a motion to deny the motion for rehearing. Do I have a seconded?
I'll second it.
That's seconded by Mark. Any further discussion on the motion? Hearing none, all those in favor say aye. Aye.
Aye.
I think you do roll call, don't you?
Let's do a roll call. Rick Riley says aye.
Mark Filato says aye.
John?
John says aye.
Kyle?
Kyle Durso says aye.
And Laura made the motion, so looks like we have the motion carries 5-0. The motion for rehearing has been denied based on the grounds that it did not meet the legal requirements. So that concludes the business. I don't have really any other business for the zoning board this evening. We do have to get some officers elected, chair and vice chair. I have 2 cases, possibly a 3rd case that's coming up in September. So again, I'm just hoping that everybody can keep that second Wednesday in September open, and I'll send out an agenda as soon as I have it finalized. If there's nothing further from the board, I just want to thank everybody for coming on tonight, and thanks for your time, and thank you, Laura, for assisting us in this, and thanks, John, again for putting this together for us as well on the WebEx. I have a motion to close.
Make a motion to adjourn.
I have a motion from John to adjourn. All those in favor say aye.
Aye.
Aye. All right, so we're all set to close the meeting.
Thanks, Rich.
Have a good night, guys.
Thanks, everyone.